morning, everybody. Michele K here, local realtor in Long Beach, and I have with me my old friend Misty Colwell, who's an estate planning attorney. And I said to Misty, I said, you know, so many times I say to people, it's so important that you have your property in a trust, but the reality of it is I don't really understand what the benefits are of a trust. And Misty was so nice to meet with me today and explain to you why you need to have a trust for your property.
There are two key benefits to holding title to your property in a trust. The first is that when a person becomes incapacitated or on their death, the cost of administering a trust is dramatically less than the cost of administering this asset through a formal probate or conservatorship proceeding. The second is that court proceedings are very intrusive. The personal information of the executor or personal representative or conservator are a matter of public record. So we like to avoid the court proceeding if possible.
Okay, all right. So, how does a trust work exactly?
The way it works is that the individual or owners set up a living trust. They transfer title from their names as individuals into their names as trustees of their trust. When that owner becomes ill or passes away, then the successor trustee steps into their shoes and can administer the property according to the terms of the trust without court supervision.
Okay, and the successor trustee, it could be your spouse?
It can be the spouse, it can be children, it can be a professional trustee or a trust company.
Okay, all right. So I just want to know, Misty, what's the difference between just having a will? Why wouldn't a will just protect you?
The will does work. It will guarantee that your intentions are carried out, but it also requires that the assets be administered in a formal court proceeding. The assets become subject to a statutory attorney's fee of approximately 2 to 3% of the gross value of the estate. It's a public proceeding that takes about 8 to 12 months to administer.
Wow, okay. There is one thing I just want to ask you. If you have a trust, you still do have a will. They're two separate things.
You do. You have a pour-over will that provides that any assets held outside of your trust are chipped into the trust, so everything's administered according to the terms of the trust by your successor trustee. Okay. And I do want to encourage people who find themselves in a situation of administering a trust for their parents or a friend or a spouse that they still need a lawyer. There are still things that need to be done to wrap up a decedent's affairs, file final income tax returns, and various other things that are required by state law, by the terms of the trust, and by custom.
Yeah, I know there's just so many forms, and I always think, you're going to remember those forms, but it's way too much. So the bottom line is get yourself a good trust attorney that can help you through this process. And thank you so much for talking to us today.
Thank you very much.